Later, do you want to try the suspension?
Yep.
Yeah.
Let me just put it on presentation mode. Oh, probably want to.
Yeah, it's good. Yeah, it's good. Yeah.
Okay. Do I need to stop share? I do, right? Okay.
Kara, you can go first.
Sure. Please let me know if you can see.
Yes.
Let me just check for controlling the slides 1 second. That's all good. Great. Thank you. And then I will stop sharing. I'm not sure how to stop sharing on this. Okay. And so may I ask, will you introduce us first before each session and then hand it over to us to share our slides? Or are you
Yes,
going to do
sure.
the introductions all at the start?
Tony will have a short introduction to you, and then if you want to add more before you speak, you can do so. But Tony will do, yeah.
Immediately before I speak, right?
Yeah.
We will have an MC to do that. In the first part, we have an MC to do that.
Sorry,
Ming-Fai,
Kara,
I
do you
haven't
mind?
seen your slides, Ming-Fai.
Yeah, sorry, Kara, do you mind if you stop sharing? If I could give me a.
Sorry, I thought you just go and share and you take over, don't you? Or do I need to stop sharing?
You need to stop sharing actually.
Okay, well, sorry about this. Would you mind telling me where I stop sharing? I don't usually use Zoom.
I think if you click on the share button, there should be options that comes up.
I think on the top of the screen, it have a button of stop sharing.
I don't have a stop button, no. I have share and it gives me all the options to share, but not a stop. Just bear with me, I'll get my IT. So I'm sorry about this.
No problem.
Just a sec. Oh, up there. Okay. Okay. You should be able to share now. Do you want to check?
Do you see the slides or?
Yeah, can see it. Yeah, can see it. Yeah.
You can see the slide.
Okay. It moves, right?
Yes.
Yes, yes,
It's
yes.
Awesome.
work well. Yeah, it's work well. Yeah.
All right, thank you. I'm gonna stop sharing now.
Good afternoon. Good afternoon.
Good afternoon.
Không mở cam được. À, được. Ừ? Tắt cam hả? Good afternoon, ladies and gentlemen. I'd like to extend a warm welcome to all of you to today's webinar, Risk Management in Infrastructure Construction Contracts, Key Takeaways for Stakeholders. As adopting a strategy that places infrastructure development as the driving force behind economic growth, Vietnam is accelerating and planning major infrastructure projects named as airports, metros, railways, seaports, and highways, reinforced by Resolution No. 68 on promoting private sector participation. In economic development, domestic and foreign enterprises are presented with strong opportunities to take part in the development of critical infrastructure projects. However, alongside these promising developments are risks for underlying disputes over these projects. To equip involving parties with essential knowledge and tools to anticipate, mitigate, and respond to potential risks, our webinar, Risk Management in Infrastructure Construction Contracts, Key Takeaways for Stakeholders, would like to share insights and practices in this area with audiences. It's my great pleasure to introduce our distinguished speakers, who are experienced lawyers from multiple jurisdictions. We deeply regret Mr. Andrews' absence due to health reasons. However, in his place, we are honored to welcome Mr. Kim Meng Phai, partner of Belden Advocates and Solicitors, to our webinar. Besides that, we are also privileged to have the presence of Ms. Kua Lei Theng, partner of Wong Partnership, Ms. Cara Howard, partner of Pin Saint Masons, Mr. Tung Trần, Senior Associate of CNC Counsel. Without further ado, we are going to launch part 1 of the webinar with the first topic, Insights Gained from Vietnam's Prior Infrastructure Development, presented by Mr. Tung Trần. Tung Trần is a senior associate of CNC with nearly 10 years of legal practice experience in construction and real estate. Before joining CNC, Tung practiced as an in-house lawyer at Novaland Group, one of the leading real estate investors in Vietnam, and as an in-house lawyer at Hoa Binh Construction Group, one of the largest construction contractors in Vietnam. These working experiences give Tung a deep understanding of real estate and construction markets, both in terms of legal aspects and market practices. In addition, Tung has many years of experience in drafting, negotiating, and managing FIDIC contracts for large-scale construction projects, and regularly participating in sharing knowledge and experience of FIDIC contracts to practitioners in Vietnam. Alongside CNC dispute resolution team, Tung has participated in numerous high-value and complex international arbitration cases at VIAC, SIAC, ICC, and other institutions. Tung has co-authored the Chapter FIDIC application in Vietnam in the Construction Law International magazine of the International Bar Association, IBA. He also a member of the Society of Construction Law Vietnam, SCLVN. Besides construction and real estate, Tung has no consulted on issues related to international sale of goods, renewable energy, hotel management agreement, and project finance transactions. So now, please, Mr. Tung.
Yeah, thank you so much for the MC for introduction. Can everyone see my slide? So thank you. So good afternoon, ladies and gentlemen. I'm Tong Jang, Senior Associate from CNC Council. It's my honor to be here today to talk about the risk management infrastructure construction contract. And my topic is I will talk about the insight from Vietnam prior infrastructure development. So what to have in my agenda? So the first one I will introduce for light infrastructure project in Vietnam about some big project we have right now, and I will talk about the most four challenge issue in infrastructure project in Vietnam. The first one about site clearance, and second about the collaboration between the employer and relevant authority. The third one about financial arrangement of the employer, and the last one is employer ability to pay claim costs. So for the first slide, I would like to introduce some number about the state budget capital for public investment. We have some number in 2023, 2024, and 2025. And the number is not a small amount. In 2025, we have a 34.8 billion USD, just only for public investment. And about some about some landmark project we have in Vietnam right now. We have a Long Thanh International Airport. It's a very big project with the phase one only is 4.7 billion USD. And we also have a Cần Giờ Transshipment Port project. We start soon, and this project have investment amount is 5.5 billion USD. We have another key national project is North South Expressway project, with the phase one is 4 billion and the phase two is 6.3 billion USD. And this one is, I think everyone heard a lot in the media in the recent time that about the North-South high-speed railway. The Prime Minister gave instruction to commence this project in the next year, and this project have a 67 billion USD. It's very big project. And we also have a Lao Cai Hanoi Hải Phòng railway project will start soon in this December this year. This project have an investment amount is 8.3 billion USD. And we cannot skip the MRT system, the vision to 2050 in Ho Chi Minh City and Hanoi. In Ho Chi Minh City, we intend to have a metro line with 25.8 billion. And in Hanoi, we also have a line with nearly 40 billion USD. So for the first challenge issue in infrastructure project, I would like to mention about site clearance. And the case study here we have is the Chợ Mới Bắc Cạn Expressway project. This project is investment funded by 100% by state budget, and the investment amount is 230 million USD. The employer is the PMU number 2 of Ministry of Transport, and commencement date is March 2025. So what happened in this project? And what happened here is after 3 months from commencement date, the Bắc Cạn Province Authority only hand over 10.6% of the project site to the employer and the contractor. And due to that reason, the project progress seriously affected due to the delay site handing over. And I think that is very common issue in almost per project in Vietnam. So what are the problem? The problem here is the resettlement and site clearance are often separated into independent component projects and implemented by local authority, but not the employer. And the site clearance program can face many difficulties due to dispute with the household regarding the compensation plan, compensation amount, so on, and the issue are beyond the employer control. and therefore the construction progress is affected due to the employer cannot control and or decide the land handover progress, or the site is handed over by piecemeal fashion, causing the difficulty and interruption in construction. And besides the land, the site clearance also involves many other issues like relocation of power line, water supply or drainage system, or telecommunication or tree or so on. So each relocation item is handled by different authority. And therefore, it's very common that the contractor in infrastructure project claim for EUT and associated costs due to site clearance issue. And the dispute may also arise due to the contract have a no clear deadline for site handover, but only provide the general provision like handover in part according to construction progress. It's very common provision in the infrastructure project. And due to the discontinuous on handover, the contractor is forced to change the construction sequence and reallocate the resource. But somehow the contractor and the employer may disagree whether the change in construction sequence is feasible or whether any additional costs incurred if the contractor required to do so. And another issue, another dispute may arise that the contractor have the right to suspend or terminate the contract due to delay site handover, or the employer can consider that the delayed site handover is the force majeure event or an exceptional event because the contractor said, the employer said that it's beyond the employer control. And the second challenge in infrastructure project I would like to mention is collaboration between the employer and authority. And the case study here we have is the Metro Line 1 of Ho Chi Minh City. It's a very famous project here. This project the employer of this project is Management Authority of Urban Railway, with total investment is 1.1 billion USD in the first place, but after that adjusted into nearly 2.5 billion USD. This project funded by the ODA fund, ODA loan from Japan, and counterpart fund from Vietnam. So what happened in this project? The example number one is when the contractor they proposed to cutting down some tree to construct the underground station, the employers they cannot make unilateral decision and had to seek approval from Department of Transport, Department of Natural Resource and Environment, or Tree Management Agency, so on. And the approval process takes 4 or 2 months to get approval, and therefore delay the construction progress. The very simple decision, but it also takes 4 or 5 months to get approval. And the second example here we have in 2018, based on the entity consultation, the employer approved to reduce the diaphragm wall thickness in some location from 2 meter to 1.5 meter to minimize the cost and construction time. And based on that, the employer instruct the VO to contractor to proceed accordingly. However, when the state audit comes to the project, they conclude that the adjustment were contrary to the procedure and require the reappraisal of the design chain. And consequently, the contractor had to wait over a year until the reappraisal result were available to get payment for the VO. So as you can see on the screen here, is the matrix for decision making for Bang Thang Suit in Metro. We have an employer in the center, but we also have a lot of other authority around the employer, and the employer during the project implementation they had to get consultation or approval from many other authority. So the problem here is unlike the private construction project where the employer is the project owner with full decision-making power, the employer in public infrastructure project is merely the entity appointed by the state to manage the project, and therefore the employer don't have a completely authority to decide on the issue during the project implementation and must seek opinion or approval from many other authority. Meanwhile, the deadline for the employer to respond to the contractor is fixed as per the contract or the Vietnamese law. And if the employer unilateral response to the contractor with approval from the relevant authority, it could lead to the violation of public investment capital management, inability to disperse or finalize the project fund, or maybe other consequence. And due to that reason, the project may face the delay and dispute due to the employer's slow decision making. And the infrastructure project often have a long duration, increase the likelihood of change in law or internal coordination procedure between the employer and state authority, making coordination more difficult. The dispute also may arise due to the lack of clear matrix of responsibility between the employer and the contractor in obtaining necessary approval from authority. For example, that when the contractor is responsible for preparing some document for the employer to seek approval from authority. So the third challenge I would like to mention here is the financial arrangement of the employer. And the case study here again is the Metro Line 1 of Ho Chi Minh City. In this project, what happened is in 2007, the project was approved by Ho Chi Minh City People Committee with total investment is around 680 million USD. But 2 years later, the total investment were recalculated and updated to nearly 1.9 billion USD, leading to the change in approving authority from Ho Chi Minh City People Committee to National Assembly, and therefore it's led to the more complicated approval process. And it wasn't until 2019 that the National Assembly approved the revised investment policy for the project. It means that before the approval, there was no legal basis for allocating the ADR capital borrowed from ZICA or dispersing the Vietnamese counterpart fund. And a second example in this project is the difference between the Ho Chi Minh City decision on capital allocation for the project in 2021 and the Prime Minister decision on capital allocation for project for the period 2021-2025. It is a symbol here that the Ho Chi Minh City decision that come first, and after that the Prime Minister have another decision, and the difference between them. And due to that issue, the Ministry of Finance required the Ho Chi Minh City to revise its capital allocation decision before any disbursement could be made. And this resulted in the situation that the project, they have money, but they cannot disperse, and they face the delayed disbursement and leading to delayed payment to the contractor. So the problem here is the long project duration often lead to the change in total investment, requiring a adjusted approval process for disbursement and payment. And for a project with foreign loan, the significant time gap often exists between the loan disbursement day and the construction commencement day due to the investment preparation, approval, and bidding process. Consequently, the remaining term under the loan agreement may not be sufficient to cover the construction period of the package, especially if the project is delayed. And when the loan agreement expires before the project is completed, it's making the disbursement and payment impossible. And the procedure for extending the loan agreement can be complex and for long because it involves various government agencies. And dispersing state versus capital or counterpart fund can also encounter the difficulty due to complex state capital management regulation involve many different ministry and agency like Ministry of Finance, Ministry of Planning Investment, State Bank, or State of Vietnam. And the last issue is the change in law also can alter state capital management regulation, particularly for project with extended deadline. So the last issue I would like to mention in my part is the employer ability to pay claim cost. And the case study here we have is the package Z3 for Phước Khánh Bridge in Ben Lức Long Thành Expressway project. This package have amount is over 100 million USD with the employer EVEC, and the contractor is Sumitomo and Cienco 4. This project funded by the ZICA loan and Vietnamese counterpart fund. So what happened in this project? The happen here is in the middle of 2019, the JICA fund disbursement ceased due to the law agreement expiration, forced the contractor to suspend the work. And by 2022, the contractor terminated the contract due to employer financial arrangement. And the contractor claimed for EUT costs incurred due to the project delay. However, because the project total investment budget did not include the contingency for such claim costs, the employer have no basis to consider making the payment to the contractor. So what are the problem here? The problem here is because the infrastructure project often have a long implementation periods, the progress is easily affected by the various factors. So it means that it's not uncommon for the contractor in infrastructure project to claim for EUT costs or other kind of claim. However, for the employer to have a basis to consider paying the claim cost, the project approval total investment must include the appropriate contingency. But the fact is not on the project have this contingency, or if they have, this may not be sufficient to pay on the claim cost to the contractor. So in that case, the employer face the difficulty in evaluating and paying the claim cost. And due to that reason, if the employer wants to pay the claim cost for the contractor, the employer must seek approval from competent authority to supplement the contingency in the total investment amount, which is lengthy and time-consuming project. And the employer also tends to rely on the third-party assessment or decision, for example, engineer or arbitral tribunal or the court for the claim cost. Because this might help the employer avoid the errors in evaluating the cost and protect them from being held responsible if the state order question the decision. So I think it's my time is going up. So in the second part, the panelists will pleased to answer the question may come from the audience. And so thank you so much for your listening. So I come back to the MC.
Thank you, Mr. Tung. The next topic, risk management in mega infrastructure projects. Singapore's approach will be introduced to us by Ms. Kua Lay Theng. Kua Lay Theng is a partner in the infrastructure, construction, and engineering practice of Wong Partnership LLP, Singapore. Triple qualified in England, Singapore, and Malaysia, she brings over 20 years of experience in construction and arbitration law to her practice. Lay Theng advises clients across the full cycle of infrastructure projects, from contract negotiation and project execution to dispute resolution. Her expertise spans a wide range of sectors and includes advising on complex construction contracts, providing real-time project advisory support, and acting in high-stake disputes through arbitration, mediation, statutory adjudication, and litigation. Before joining Wong Partnership, Lay Theng was a partner at a leading law firm in Kuala Lumpur, where she focused on construction disputes. She has extensive experience advising on large-scale infrastructure projects across the ASEAN region. She also previously served as Deputy Registrar of the Singapore International Arbitration Center, SIAC, gaining valuable insights into institutional arbitration proceedings. She is a fellow of the Chartered Institute of Arbitrators, UK, and the Singapore Institute of Arbitrators, as regularly sits as arbitrator. Lay Theng is in panel with SIAC Reserve Panel, the Asian International Arbitration Center, AIAC, and the Borneo International Center of Arbitration and Mediation, BICAM. Lay Theng is recognized in the Legal 500 Asia Pacific Guide 2025 as recommended lawyer for construction Taiwan and the best lawyer in Singapore for construction law. Please, Mr. Lay Theng, Ms. Lay Theng.
Thank you for the very kind introduction. And I would like to thank CNC Council for organizing this webinar and inviting me to participate. I am very happy to share my perspective as a Singapore practitioner on risk management in mega infrastructure projects. So in this presentation, I will first briefly touch on types of risk. Then I will deal with Singapore's approach covering contractual risk management, collaborative contracting, the Singapore Infrastructure Dispute Management Protocol, which is Singapore's own dispute board. And lastly, a new regime called the Integrated Appropriate Dispute Resolution Framework 2024. And if there's time at the end, I will also discuss a little bit on technology as a tool to manage risk in infrastructure projects. So first, these are the types of risk in infrastructure projects: technical, time, cost, legal, regulatory, stakeholder, and external. So how does Singapore approach risk management? Well, this is actually more my observation rather than any formal policy of Singapore. There is a strong proactive risk identification, allocation, and mitigation. There's also an emphasis on planning, early intervention, for example, the front-end engineering design. And now there's a big promotion for collaboration among industry stakeholders. Singapore's philosophy is that risk lies with the party best able to manage it. So here are some standardized contracts that are used in Singapore projects. The first, the PSS COC is used in government projects. Of course, we also use FIDIC contracts where international parties are involved. The last two contracts are in the private sector, so I will not touch on them. So contractual risk management in Singapore. One way of managing risk is to use balanced contracts with specific risk clauses. So here I would like to highlight that the public sector standard form, actually, the PSS COC, is a balanced contract. This is quite surprising. It is quite fair and even favorable to the contractor. I'll just give a few examples. The first would be retention. Under the PSS COC, there is no retention. The employer doesn't retain anything. This is to be compared with the other standard forms of contract like FIDIC, where half is released after TOC and the remaining half after expiry of DNP. In respect of notification period for claims by the contractor, the public sector standard form actually gives the contractor quite a lot of time, 60 days to make a claim. This is to be contrasted with other standard forms of contract, where it's usually 28 days or a month. In relation to unforeseen adverse physical conditions, the contractor is allowed to claim for EOT and L&E if the adverse physical conditions are not reasonably foreseen by an experienced contractor. This is similar to the Red Book, but of course not the silver turnkey or EPC contract, where the contractor basically accepts all risks. And also, I like to point out in respect of loss of profits, under the PSS COC, the definition of L&E includes 15% of direct costs in lieu of profits. This is quite generous to be compared with the definition of cost plus profit, which includes a default of 5% of profits for all three books in FIDIC, notwithstanding the different risk profiles. And for this slide, I would just like to highlight the fluctuation provision. In the PSS COC, it is a default that there will be a fluctuation clause to adjust the contract price to take into account the rise and fall of material prices, contrasted with other standard forms where even if there is a fluctuation clause, it is an optional clause for parties to opt in. So from balanced contracts, we move on to a different form of contracting framework, which is collaborative contracting. So what is collaborative contracting? It is a model based on the recognition that there can be mutual benefits for all party stakeholders for a more cooperative mutual relationship. So it's a move away from the adversarial position where parties will try to push the risk down the supply chain and enforce strict onerous contractual terms on each other, for example, LDs and calling on bonds. The objective of collaborative contracting is to address typical problems associated with the traditional contracting model. For example, misaligned commercial interests, blame game, and minimum compliance. You see, parties will try to minimize costs to maximize profits. And contractors will do the minimum required of them so that they are not in breach of contract. An example is in a fixed price build-only contract. During construction, say there is a design found to be defective. So the contractor in a traditional contracting model has no financial incentive to suggest solution if the solution increases his cost when his fees are fixed. So that's why in January 2022, the Singapore Academy of Law Reform Committee published a guide on collaborative contracting in the construction industry. So these are the common features of collaborative contracting: early warning, dispute avoidance, early dispute resolution, and early contractor involvement, collaborative partnership, where the duty to act in good faith is made a contractual commitment because Singapore is, after all, a common law country, and also KPIs based on contractors' performance. The Singapore Academy of Law suggests 4 models for collaborative contracting. In this diagram, you will see the least collaborative and risk-sharing model on the left, and this increases to the most on the right. So I'll just point out the 2 extremes. On the left, you have partnering, where this is basically a non-binding partnering charter. And on the right, the other extreme, project alliancing, where the owner, all consultants and contractors all enter into one contract, one agreement, a single multiple agreement with gain share, pain share payment linked to agreed KPIs. And this is the radical part, with no fault clause, where parties waive their legal rights to sue each other for delay, breach, or negligence. So in 2017, the Building Construction Authority, or BCA, introduced option model E, collaborative contracting, to the PSS-COC, and the principles include collaborative working relationship and to act in the spirit of mutual trust and cooperation, a set of KPIs, early notification, and dispute board. In April 2024, BCA developed Y clauses to align the NEC 4 suite of contracts with Singapore's laws. I think you would recall that the NEC 3 was used for the London 2012 Olympic Park, which was delivered on time and within budget. Then in January 2025, the BCA further introduced further clauses on modes of dispute resolution, including dispute board. And the last point I'd like to make on this is that the BCA has an academy which offers training and courses targeted at procurement professionals, including a certification program on collaborative contracting. Now, I just like to go to this slide to introduce Singapore's very own dispute board. It's called the Singapore Infrastructure Dispute Management Protocol, or SIDP in short. This was launched by the Ministry of Law in 2018, and it is a comprehensive dispute management mechanism to help parties proactively manage differences from the start of the project by appointing a dispute board comprising of 3 neutrals. Ideally, it would be an engineer, a QS, and a lawyer. This is recommended but not compulsory for construction projects of more than 500 million Singapore dollars in value, and there is a standard clause to incorporate this into any construction contract. So the SIDP has three different dispute resolution approaches: mediation, opinion, and determination. And the binding effects are as follows. For mediation, obviously, if parties settle and enter into a settlement agreement, this is final and binding on the parties. For an opinion issued by the board, it is not binding, but will become binding if no notice of objection is served within 28 days. It is not final, and you can always challenge this in arbitration. For the determination, it is binding on the parties, but if one party does not serve a notice of dissatisfaction within 28 days, then the determination becomes final and binding. So what are the projects which adopt this collaborative contracting and SIDP? The first is the Punggol Digital District. This was developed by the Urban Redevelopment Authority. This is Singapore's first smart integrated business, learning, and lifestyle hub. And it was announced in 2018 and expected to be completed in 2026. This is the first major public project to incorporate PSS-CoC option module E. And so far, the results are very promising. There is already a cost savings of about 10% compared to the initial estimates. And as of last year, it is 6 months ahead of schedule. So this is thanks to the features like early notification register and the dispute board. The other public project which incorporates this PSS-CoC option module E is the National Service Square. Now, I'd like to introduce the Integrated Appropriate Dispute Resolution Framework, or INTEGRAF for short. Unlike the SIDP, INTEGRAF is not just for infrastructure disputes, and there is also no recommended project value to use INTEGRAF. INTEGRAF was launched by the Singapore Mediation Centre in 2024, so this is very recent, and it is a collaborative dispute resolution scheme to guide parties to unbundle disputes and apply the most appropriate dispute resolution mechanism to each aspect of the dispute. Basically, different parts of the dispute may be resolved by different modes of dispute resolution. For example, if you have bilateral disputes between two parties, can refer that to arbitration. For multi-party disputes, you can refer it to a court such as the SICC. That would be the Singapore International Commercial Court, which was established in 2015. And of course, you can mediate certain other aspects of the dispute. So in a construction dispute, for example, you could have many defects claims. So the court could interpret the contract to decide on what constitutes a defect first, and then an evaluator or assessor will answer what are defects against the court's interpretation. So for this, there's also a model clause. So how are disputes resolved under INTEGRAF? First way is with a standing conflict avoidance board. This is very similar to a dispute board. The second is an ad hoc conflict management, where if parties are in a dispute, they can contact the Singapore Mediation Centre, and the Singapore Mediation Centre will appoint a conflict management consultant who will review the dispute and the relationship between the parties. The consultant will consult the parties and formulate an ADR plan and recommend neutrals to facilitate the resolution of the dispute. The consultant may even recommend that a CAB be appointed for the dispute. Lastly, I'd just like to talk a little bit about technology as a risk management tool. I will skip this slide because I think most of us are familiar with BIM. And just to share that in 2014, the BCA mandated BIM submissions for all projects with a gross floor area of more than 5,000 meters square. And in December 2023, BCA soft launched something called CornetX, which is an online platform to streamline the regulatory approvals via coordinated BIM submissions. So it's basically a one-stop shop for all regulatory approvals. And you compare this to what is happening today for the non-Connect X submissions, where building projects typically have to go through more than 20 approval touch points and different agencies providing individual responses. So this is what Tony mentioned earlier, the maze in relation to the Metro Project Line 1. So with Connect X, it is hoped that this will cut down delays due to regulatory approvals. I'd like to point out one MRT project first. This is the MRT Downtown Line. It's developed by the Land Transport Authority, or the LTA. Yes, this project uses BIM, but what I wanted to highlight in this project is a horror story for LTA, which is when the main contractor went bankrupt halfway through the project. So the Downtown Line is a 20.7 billion complex underground rail project with multiple contracts. It was first announced in 2001 and finally opened in 2017. So the delays were mainly due to the Austrian main contractor, Alpine Bau, who went bankrupt in June 2013, and this obviously halted construction. LTA quite quickly retendered contracts and appointed new contractors and deployed additional manpower to try and rush the job. So I believe LTA has learned quite a number of lessons from this incident. The next project is the North-South Corridor, which is developed by LTA as well. It is basically a 7.47 billion Singapore dollars dual layer. If you look at the second picture at the bottom, there are two layers of transport corridor, including an expressway at the bottom with a viaduct and a tunnel. And on top, ground level, there are streets for walking, cycling, public transport, and community spaces. So this is a very challenging project because of the geology and because it also runs through the very heart of Singapore, a very busy area, interfacing with existing MRT and underground utilities. Of course, there were delays because of COVID and also managing different stakeholders, especially residents and the public. But now the project is on track to be completed in 2019. The technology used here is integrated digital delivery and analytical modeling to visualize geotechnical challenges. And my last slide for this presentation is on the Tuas Mega Port, which is developed by the Maritime and Port Authority of Singapore. This is a 20 billion Singapore dollar mega port, which is expected to be the world's largest fully automated and digitalized port by 2042. It will occupy 1,337 hectares of reclaimed land, and it uses BIM quite a bit. It uses the digital twin, which is basically like a live digital replica of the asset for safety management and enhanced efficiency. And also BIM data is integrated into centralized system, allowing future facilities management team to plan and execute building maintenance works later. With that, I end my presentation. Thank you very much for listening. I will hand it back to the MC.
Thank you, Ms. Lê Theng. For the first topic of part 1, Mr. Kee Meng Fay will tell us about Malaysia's infrastructure journey, navigating risks in public projects. Meng Fay is a senior partner at a boutique law firm in Kuala Lumpur, specializing in construction, energy, and infrastructure law. He has over 15 years experience in this specialist area, having practiced both in Singapore and Malaysia. Apart from dispute resolution, his practice focused on drafting and advising on construction contracts, offering valuable guidance on project management for a wide range of infrastructure projects. This includes urban transport, airports, high-speed railways projects, high-value commercial developments, data centers, and mixed-up use projects encompassing Grade A corporate office tower, residential tower, and retail space with a cross-development value. Meng Fei leverages his legal expertise alongside a seasoned understanding of the industry to deliver solutions for his clients. He empowers his clients through training to strengthen their in-house legal, project management capabilities and ensure they remain resilient and adapt within the industry. Meng Fei is a fellow of the Malaysian Institute of Arbitrators, MIARB, and the Chartered Institute of Arbitrators, CIARB, a panel arbitrator of the Asian International Arbitration Center, AIAC, and an accredited AIAC adjudicator. Please, Ms. Meng Fei.
Good afternoon, everyone, and thank you very much for the invite, CNC, to give me a chance to share our Malaysian experience. I hope everyone can see the screen on my slides. Thank you very much. I think as introduced, I'm actually stepping in from Mr. Andrew Heng from Mrs. Zain, Megat and Murad. And whilst I am not as aesthetically pleasing as Andrew, I do hope that I'll try to make it up in terms of the content and try to get this through. Now, insofar as my presentation is concerned, it will, in essence, cover 5 different areas. I'm going to bring everyone through the Malaysian experience insofar as the land acquisition risk, the geological challenges that we will see, financial risk, the delay risk and budgetary and technical risk, which we have balanced it through either the PDP or a PPP model. And lastly, I'll talk about risk insofar as legislative and political changes are concerned. So without further ado, I'm just going to jump straight into the first topic, land acquisition risk. I believe Tony and Leighton have both covered quite a fair bit, but this is what we can see from the Malaysian context. This is a project that we've called the Pan Borneo Highway. And as you can see, the project at that point in time had only achieved 1.6% progress over 8 months. And largely the reason for that delay is due to land and property assessment issues, namely land acquisition problems. And this then highlights how land acquisition is a critical issue in infrastructure delivery timelines that needs to be considered. Now, moving forward, we also see land acquisition issues coming in the form of the Klang Valley Mass Rapid Transit Line, Project 1. So the distinction being the Pan Borneo was a brownfield project, so land acquisition trying to get through largely forest and indigenous lands, whereas the land acquisition in Klang Valley Mass Rapid Project, MRT, was right in the city center, and then you have the different dynamics of that issue. And the risk that you can see is that the PDP partner at that point in time in 2016 had to face a 300 million claim for alleged breaches in land acquisition contracts. And that highlights the importance of understanding and appreciating land acquisition as a risk in mega infrastructure projects. Now, why have I highlighted land acquisition for the reason is that, well, put it this way, land acquisition is the first thing and most important thing in terms of site possession is concerned. And in Malaysia, there are in fact quite a fair bit of different things that needs to be considered. And I think these risks could actually be something that is largely common as well in other jurisdictions. So like in Malaysia, you need to balance issues such as federal and state land, There are also issues of customary rights, where there are indigenous people in brownfield projects that may claim to have customary rights over certain areas of land. And these are not something that can come up from your usual land survey or title checks. So insofar as these kind of brownfield projects are greenfield projects, sorry, are concerned, aside from your usual conducting your land surveys, title check, environmental assessments are concerned, some of these issues may crop up and may in fact cause delay and impede the progress of projects that needs to be considered earlier. So having learned and looked at these projects as risk, what has the Malaysian context learned to improve? We have then started learning how to manage our compensation management much earlier. We have learned how to secure land much earlier before awarding contracts, and in fact, necessarily including much longer lead times within project programs to ensure that lands are being acquired much earlier so that projects can move on as smoothly as possible insofar as mitigating land acquisition risks are concerned. We have also put in place much more advanced community and stakeholder engagement programs to also ensure that surrounding communities and landowners are much more aware of what projects are going on, which pieces of land will be acquired, and if anything, how does it impact any of their livelihoods as part of our risk management programs that are now required in doing mega infrastructure projects. I'm jumping a little quickly to make up for time. The second risk that you will see is geological challenges. Now, geological challenges, I'm going to largely focus on public infrastructure projects that are in cities and dense population, because I think that's a bit more in line with, I think, what's happening in Vietnam at the moment. So this is an example in 2020 when we were doing the MRT Putrajaya line, and what the contractor, despite having done its due diligence and having to tunnel through an underground, realized that they had much more karstic stones that was undetectable through its original geological studies. This is another example of the NKVE line. It's a public highway project that later on led to having sinkholes, which was again an issue that couldn't have been detected much earlier. So when it comes to public infrastructure projects in cities and dense population areas, I think there are quite a few things when it comes to geological that contractors needs to consider. These are, for example, karstic limestones, granite, water table levels that may change, especially if you have a lot of underground issues, and also having to balance what is already existing on your surface. So especially if the projects are happening in Vietnam, what we do see is that you do have a lot of, the dense population that's already sitting on the surface. The question is, if you do have any underground issues and underground projects, how do you then, and how does contractors, and what do we need to do to balance those risks? Now, another type of risk insofar as dense populated areas are concerned are relocation of utilities. Now, I believe Tony has actually talked about this, but likewise in the Malaysian context, when we had to do the MRT line, a lot of the delay and a lot of issues were faced by contractors, largely due to having to relocate utilities. Because these are all buried underground way beforehand, and you now have to relocate it to cater for where the MRT lines were going. And an added difficulty and challenge in terms of the risk is concerned is that there are multiple stakeholders that actually are responsible and insofar as giving approvals for these utility relocations. In Malaysia, we have Syabas, who is responsible for water. We have the TNB, who is responsible for electricity. And then we have PLUS, who is the highway concessionaires, who has authority over where the highways are, and if you do have permits to work beneath or on the highway during your infrastructure projects. So the question I will pose to everyone at the moment, and something that we will discuss in the second session, I believe, is it really fair to allocate all of this risk to the contractors who are doing the work? And more importantly, when it comes to public infrastructure projects, is it necessarily fair that we allocate all coordination efforts to contractors when in fact some of these entities and stakeholders are either government-linked entities or government-linked stakeholders, which perhaps if there's some intervention or some cooperation between the contractor and government could perhaps help save time and costs. These are questions I believe that I will talk about later, but to highlight and put a place marker insofar as risks are concerned, this is what we can see from geological perspective, as well as having to move utilities in populated and highly populated dense areas. Now, it goes without saying actually that another type of risk that is constantly seen in public infrastructure is financial risk. Now, financial risk could happen for an array of reasons, as you can see from screen. It could either be due to an underpricing of the projects, or it could be due to a change in design, unforeseen site conditions and delays, changes in law, which I'll talk about a bit later, and obviously delayed payments. Now, I will touch a bit in down a couple of slides later as to how we have, in the Malaysian context, adopted the PDP and a PPP model to try to balance this risk. But largely, financial risk either comes from the fact that there could be an overestimation of your project revenues and an underestimation of project costs that then leads to a serious cash flow mismatch. And then obviously there's the issue of delay in government disbursement of funds, which then could lead to, again, further delay. So what has the Malaysian experience taught us, and how do we now try to balance that financial risk? Starting from the onset, we have then learned how to choose the right contractual structure for a different type of infrastructure projects. Not everything works insofar as a PDP model is concerned, and not everything works well for a PPP, and not everything works well from your traditional government-based finance project. So depending on the scale, depending on the complexity, and depending on what's involved, we have now learned to choose the correct contractual regime. Number two is that the Malaysian context, we have also learned how to set up SPVs to deal with budgetary issues. So take, for example, from the MRT line is concerned, we have the MRT Corp. For the East Coast Railway line, we have set up the Malaysian Rail Link Company. So these dedicated SPVs are special purpose vehicles because they either already have experience in previous projects, or they are formed with having the correct personnel and people with the relevant experience in managing these projects. When they set in these companies and deal with the PDP partners or the PPP contractors, what will happen is that they will now be able to streamline your financing flows. They are able more to now centralize project budgets. So despite perhaps in certain projects, we having different packages and different contractors, but it all comes back to the special purpose vehicles who will now have the experience to control the budget issues so that it doesn't go beyond what is necessary. And these SPVs also act as a single point authority for them to improve coordination, transparency, and delivery accountability. Now, if in the worst case scenario, payment issues still do occur, be it from the government to main contractor level or the main contractor down to your subcontractor levels, then I think from the Malaysian context, we have also now have support from the legal regime. We have the construction courts who are now specialized and able to deal with infrastructure-related projects. And obviously, in 2014, Malaysia has introduced the Construction Industry Payment Adjudication Act, which will then help payment issues because that adjudication process is a much shorter process. It's a much more regimented process. It's compulsory, whereby as long as it's related to construction-related payment disputes, then whether you are a subcontractor, sub-subcontractor, or a main contractor, you have access to it your dispute gets done between anywhere between 4 to 5 months, and it has a temporary binding effect, which will then ensure payments to flow through. And then it also has ancillary rights, which allows the contractor to either suspend or seek direct payment from principals, so on and so forth. So the legal regime in that sense has been uplifted so that we can now deal sufficiently with any payment-related issues. Now, I've grouped delay, budgetary, and technical all in one risk, basically, because that allows me to move on to talking about the PDP and the PPP experience. And traditionally, in Malaysia, we used to have project management companies who comes in to deal with projects, meaning your traditional sense. You have your employers, you have your project management team, and your contractors, each being responsible for its own domain. But I think since the 1980s, we have tried the PPP for the North-South Highway project. But in the 2000s, when it came to the Klang Valley MRT, the PDP was a model that we have decided to adopt. And that, in essence, is an enhancement of the project management role, which then we have built-in incentives and penalties that helps motivate the PDP partner to actually deliver the project on time and necessarily within cost. Now, why did we then choose to adopt the PDP model? I think that's already on screen. I won't spend too much time on it. But in essence, it was a single accountability risk transfer mechanism that we have adopted. This is also motivated by the fact that we have seen the PDP model work not just within Malaysia, but also across the globe in different projects. Having moved from traditional, we moved to PDP. And then in the recent times for MRT Line 2 and Line 3, and in fact other projects, we have now tried to move on to the PPP model, which in essence, it's a slight departure from the PDP side insofar as having the private entities not only having to build it, but to some extent financing it and all that as part of the package. And what you can see is that these are some of the examples of completed PPP projects that we have, and the ongoing PPP projects that we are using this model, which will help negate any financial risk in that sense. Lastly, when it comes to public infrastructure projects, the important thing to note, and sometimes it's a bit difficult to balance, but these are some of the real risk issues that contractors will face especially if it's a cross-border type of infrastructure project. You have political and legislative risk that you need to balance. So in Malaysia, for example, one of the key things or the key concerns did happen was a change in the tax regime. We had moved from GST, Goods and Services Tax, to SST. And I think even in this year itself, we have reverted back to the SST model. And right now, contractors and the government are trying to have dialogues to see how we can mitigate the impact of it. A change in a tax regime where you now suddenly have 6 to 8% being imposed on the project does create financial strain to a project. So this is a risk that contractors will need to be aware of. Another example is that the ECRA project, for example, was suspended at one point due to government change. I think without saying, in any jurisdiction, most of the during the COVID period, we did see a change in law insofar as having restrictive working hours and working conditions. And for example, in Malaysia, what we have seen and developed is that we recently see an increase in imposition of safety standards. The change in law happened this year with the Occupational Safety and Health Amendment Act. Although it's 2022, it came in force this year, which now increases the level and responsibility the contractors needs to bear when it comes to safety-related standards. And just to add a little, aside from what you can see on slide, is that change in law also happens not only for safety standards. You will also have, with the recent trend of ESG, you will see that governments having rectified certain international conventions will then have increased standards and protections for human rights. So be it when it comes to minimum wage, for example, or environmental standards. All of this, whilst it looks from a macro level, does have a direct impact when it comes to implementing your public infrastructure projects, because it will hit your bottom line insofar as you now having to adopt these higher standards or implement additional measures that you may not have foreseen at the point in time when you tender. So these are the 5 actual risks that contractors will face in public infrastructure projects. And I believe I have ended my presentation and done it within the time allocated to me. I believe questions can be taken in session number 2. Without further ado, I'll hand it back to the MC. Thank you very much, everyone, for listening.
Thank you, Mr. Kim Meng Phai. And last but not least, topic 4, top risks in public infrastructure and energy projects across Asia and the Middle East would be presented by Ms. Cara Howard. Cara advises clients on major construction, infrastructure, and energy projects. Recent energy work includes preparation of claim submissions for hydrocarbon processing facility contract in Saudi Arabia, advising on disputes under combined cycle power plant project in Bangladesh, and the resolution of a joint venture dispute for combined cycle power plant in Thailand. Recent infrastructure work includes managing a subcontractor's defense in ICC arbitration on a transport project for Silverworks in Qatar, advising a mining conglomerate on its defense to a contractor's claim in Australia, and guiding a global consultancy on a claims raised by an owner on a Hong Kong Silverworks project. Cara has extensive experience on FIDIC, NEC, and Hong Kong GCC construction firms. Cara has acted as a counsel in arbitrations under rules of HKIAC, ICC, and SIAC, seated in cities in the Middle East, Europe, and around Asia. She has also acted as sole arbitrator on HKIAC and ICC cases. She listed in the 2023 Legal 500 Arbitration Power List, Hong Kong region, and ranked recommended with WW Lexology 2024 Construction and 2024 Arbitration Future Leaders. Cara is qualified in England, Hong Kong, and Western Australia. Her experience advising Japanese enterprises, Japanese fluency, and understanding of the culture has placed Cara in a prime position to lead the firm's initiative in relation to Japanese contractors in Asia Pacific and Middle East, and led the firm to win the ALB Japan Foreign Law Firm Award 2023 and be listed as finalist for 2024 and 2025. So now, please, Ms. Cara.
Hello, can you hear me?
Yeah, we can hear you. Yeah.
It's my absolute pleasure to be here today, and I'm very grateful to have the invitation from CNC Council. I'm here to speak to you today because I have experience in construction projects in Asia and in the Middle East. And for the last 17 years, I've been working predominantly on construction, infrastructure, and energy projects. The things that I want to raise to you today have been focused on key topics, including time, cost, performance, claims, dispute resolution, and enforcement. And of course, each of these topics themselves could be the subject of an entire hour presentation, so I'll be moving quite quickly. But the things that I want to emphasize the most in this presentation is the importance of understanding the law that applies to your project. And in some cases, there can be as many as 3 different laws that could apply to your project. You have the law of your contract, obviously. Then you will have the law that is mandatory, that applies in the jurisdiction where your project is being built. It may not be the same as the law of your contract, but that mandatory law will apply, and it will include environmental law, labor law, health and safety law. For example, also in Hong Kong, there's adjudication, security of payment legislation in Hong Kong for adjudication. And that means that your disputes will have to go first through an adjudication process by law. Similarly, the statute of limitations of every jurisdiction will apply as to how long you have before you can bring your claim to dispute resolution. So the mandatory law of the location is also an important factor to consider when you're entering into a project in a new jurisdiction. The third law that's important to remember is the law of the dispute. So in your contract dispute resolution agreement, you will have selected the applicable law of the arbitration, and that is the law of the seat. And so the law of the seat will have an arbitration law that provides the procedure and the rules within which you need to operate your arbitration. And then on top of that, you will have the rules that are agreed in your arbitration agreement, and that provides further procedure as to how you operate your dispute. So you have to remember that there's 3 different types of laws in place, and I've had situations where it's at least 2 of those are different, or sometimes 3 different. I've had cases where, for a project in Thailand, we had a Korean seat, so the dispute resolution was operated based on Korean law for arbitration. I've had other cases where you have an Indonesian project, but it's a Singapore seat, so the arbitration has to take in consideration Singapore arbitration law. So it does get pretty complex when you're managing these types of projects and disputes. And so it's important to always get advice on the applicable law from the outset. So with that as the first step, I would then go into the actual elements that I want to raise today as the key risks in public infrastructure and energy projects. So the first is time. So in every project, there will be a date for completion for the works. And that could be because the employer is seeking to have a subway opened on schedule to be in line with a particular international event, for example, Rugby World Cup. Or you might have a public works project where there's a government commitment to have a bridge open by a certain deadline. Or you might have an energy project where there's obligations under your offtake agreements, which mean that you have to have your plant constructed and ready to go to meet your obligations under the offtake agreements. And so time is very important. And so the contract includes many provisions about time. Now, in terms of disputes, the areas of concern that I see the most in relation to time are set out on the slide. So we have a need for extensions of time provisions under your contract. There's often liquidated damages, an entitlement to prolongation costs. There is also a need to establish the cause of delay. There are various issues with concurrent delay, particularly because the law on concurrent delay is not the same in many jurisdictions. And also there will invariably be a requirement for the contractor in many cases to accelerate the works to meet the deadline for the completion date. So what I would like to say in relation to each of these is that the extension of time provision is there typically to protect the employer. It's protect before the employer's right to claim liquidated damages. Under common law, and so in most common law jurisdictions, you will have the risk of time being set at large if you don't have an extension of time provision in your contract. And this means that your liquidated damages provision won't apply, and you'll be left having to claim general damages for the losses that you have suffered. And that has a whole lot of incumbent difficulties, such as having to establish the actual breach, then causation, mitigation, and the loss itself. And it can be very difficult to do so in a construction project of a large size. So employers want to keep liquidated damages provisions in their contract. But my experience is that liquidated damages and the court's interpretation of liquidated damages changes a lot depending on the jurisdiction you're working in. In common law jurisdictions, many of you will be familiar with the fact that liquidated damages can't be a penalty, and they'll be unenforceable if they're deemed to be a penalty. Except the threshold to establish their penalty is quite high. All you need to do is show that the liquidated damages sum is out of all proportion to any legitimate interest of the innocent party. Essentially, you have to show they're extravagant. But then in contrast, though, you have the laws of some civil law jurisdictions. For example, I've been working recently on Saudi cases, and in Saudi Arabia, it's possible for a court to go in and open up your liquidated damages clause, and where your actual loss is significantly less than the liquidated damages sum, they can reduce your entitlement right down to the actual loss. In Saudi, you can also have an increase in liquidated damages in circumstances of gross negligence or fraud. And in contrast, just next door in UAE, you can have an increase in your liquidated damages even without this requirement that it be for fraud and for gross negligence. And so I can't emphasize more how important it is for employers seeking to rely on liquidated damages clause, and also for contractors seeking to avoid them, to make sure that they get advice as to how a liquidated damages clause will work in the context of the jurisdiction where the project is, or in the context of the contract, the substantive law of the contract. Okay, I'm going to go to the next slide to speak on issues of costs. So the areas of cost that I think are most relevant for construction contracts are listed on the slide, and this is based on things I've been involved in recently. So one of the key areas where additional costs are incurred and additional costs are claimed is where there's variations to the works. Obviously, when a project is tendered, there will be various unforeseen conditions or unforeseen events that take place, and the employer may need to change their requirements. They need to change the scope of work, and for this reason, they have an ability under the contract to order change or variations. And in some cases, the contractor will be able to resist these if they can show that they're technically difficult or impossible. But in most cases, they'll be required to comply with the variation. And of course, the question of whether a variation is particularly for design development under design build contracts and EPC contracts, what I see is a number of issues taking place where a client contractor will consider that the instruction to change a design will actually be considered to be a variation of the scope of works, whereas the employer will be considering it to be actually just design development. And in that sense, we see a lot of disputes on variations in respect of design development. The other two aspects I want to raise on this slide is in relation to force majeure, change in law, and price escalation. During the last few years, we've seen a number of claims and a number of disputes arising out of COVID, the war in Ukraine, and also sanctions imposed as a result of the Russian entities being sanctioned by the US and being sanctioned by the UK. And it depends to a large extent on your contract provisions as to whether you can claim cost as a result of those events. And so we've been working with many parties to work out whether, for example, the sanctioning of a counterparty preventing payment to that party amounts to an event of force majeure under their contract, or whether COVID arising as an epidemic, a pandemic, means that it's an event of force majeure, and whether that you're entitled to cost for that force majeure event or only extension of time. In addition, change in law, as was mentioned just earlier by my colleague, is also an important element for raising claims under your contract, particularly for COVID situations and sanction situations and circumstances when the law that's applicable to your project in the jurisdiction has changed. And so, as I said before, the types of law that apply to your contract that can be changed would be environmental law, health and safety law, and various government regulations. And with the transition in energy projects we've had in the last few years, we're seeing significant change in the regulatory process adopted in many jurisdictions, where this gives rise to an entitlement for a contractor to claim for change in law. The other element I wanted to raise was in relation to price escalation. And price escalation is usually featured as a clause in your contract that allows you to claim where specific elements of materials increase in price. Usually there will be a clause with an entitlement to price escalation for specific materials, and there will be an index specified. And where that index shows an increase, then you can claim an increase. Where it is a decrease, there may be a decrease applied. However, in many cases, the employers will try to avoid a price escalation clause because they don't want to pay anything extra. And in that case, contractors need to remember that it may still be possible to claim the effect of a price escalation in their materials based on other entitlements under the contract. For example, imagine if you have a compensable delay where the employer has caused a delay and you're entitled to claim for the consequences of that. Where you can establish that but for the delay, you would not have suffered the price escalation in the later period of the contract, then it's potentially available to you to claim that increase in price due to that delay. And so simply because you don't have the clause doesn't necessarily mean that you can't retain the benefit of the claim. And that's why it's always important to reach out to your lawyers to make sure that you have covered off all bases under your contract to raise the claim. I'm going to move now, given time restraints, to the next slide, and I'm going to talk about performance. Now, I wanted to speak about performance in particular because the recent QMUL survey that we undertook with Queen Mary University of London on energy arbitration showed that design and performance issues were likely to be the largest cause of dispute in the next 5 years for energy transition projects. And this is largely due to the rapid uptake of technology, previously untested technology, and the uncertainties that are incumbent with using new technology. And so I just wanted to touch on a few ways that parties can consider the risks in relation to performance. Firstly, I want to talk about design, because there's a lot of claims that arise through design liability. An EPC contractor, a design and build contractor, must understand that they hold the risk of design liability under their contracts. And that would be the case whether or not there is a reasonable skill and care obligation, which is a lower level of obligation in your contract. And so if you're a design and build contractor or EPC contractor, or if you have any design scope in your contract, be aware that you may be held liable for the design, particularly where you're completing the employer's design as part of your scope of works. The next thing I want to speak about is ways to protect yourself. And so including performance warranties in the contract does help to protect you from where the outcome of the project, the particular performance that's sought to achieve, is not met. And so often we see performance guarantees, performance warranties, or even performance bonds in place to protect employers, or for main contractors down the line by main contractors, to ensure that those performances are met. Another element for protection that can be considered is a collateral warranty. So imagine you have an employer who is seeking to build a solar park, and it wants to ensure that it is covered by all of the suppliers that are feeding into the EPC contractor. And so they will likely seek to have collateral warranties with those suppliers, because otherwise they don't have a direct contractual entitlement to claim against that party. And so what we see is the EPC contractor they directly contract with has a 2-year defects notification period, but the collateral warranties with the suppliers, who form the broad part of the scope of works for a solar plant, will actually have much longer design liability periods for up to 15, even 20 years. Next, on bonds. Now, in the last few years since COVID, we've had many issues in relation to bond calls, whether that's us calling or us protecting a call on bonds. And it's because since COVID, there's been a large number of insolvencies in the construction industry. And so employers are seeking to protect themselves by calling on the bonds before you get to a state where there's any insolvency. The issue with that, of course, is that contractors may seek to injunct the call if they can find grounds for it. So we've been involved recently in injuncting calls on bonds in the state courts or injuncting bonds calls in emergency arbitration. And one thing I think that people are not very familiar with is the fact that you can get emergency measures, like interim measures, in emergency arbitration in the same way that you would go as going to court for a bond call for an injunction. And what we've been doing is looking at the jurisdiction where the bond is going to be injuncted, which is usually the jurisdiction of the bank that's providing the bond. And we see that the requirements to get an injunction are much more severe, or the decision maker is much less impartial, much less independent than would be the case in emergency arbitration. And so what we've been doing is going to emergency arbitration instead and having a impartial, well-experienced, very well-known and qualified decision maker making the decision on the bond call injunction, and in that way securing injunctions for our construction clients. So these are some of the ways you might want to limit your risk in relation to performance. And I will then move to the next slide, which is dealing with claims processes. So I appreciate this is a rather whirlwind trip through all of the risks under a construction contract. And I think we'll get to a few more of the specific examples when we get to the questions in the next phase. But just bear with me here while I go through some of the claims processes risks. So the key elements I want to raise on this slide are the fact that not only do you need to know of your contractual entitlement to claim, you need to know of any entitlement to claim at law as well. Plus, you want to have measures in place internally to ensure that you can implement these claims processes and have internal training on the timing, have notice templates, have flowcharts, have registers of notices, have regular meetings to ensure that internally you satisfy all your obligations in relation to claiming your entitlement. And as a result, it's important to make sure that you are prepared up front for these types of things. I've had cases where 1,000 design drawings were changed the day after contract was set up, and the contractor in that case did not appreciate that it had only 5 days to issue its notice. And so in such cases, you have to make sure that you complete your notification process within the timeframe specified. In terms of notification requirements, it's important to remember that the jurisdiction that you're working with will also impact your entitlement. So in common law jurisdictions, claims and notice requirements are really strictly enforced. They're considered in most parts to be conditions precedent to a claim. And so if you fail to comply, then you'll lose your time, you lose your entitlement to claim entirely. On the other hand, in many civil law jurisdictions, it's not quite so clear cut. In some jurisdictions, you may be able to get around the situation. So it's important to check your local law to understand what those requirements are, and most importantly, just to comply with them so there's no dispute on this issue in the first place. In relation to evidence, I can't say enough how the absence of any supporting contemporaneous documents will detrimentally affect your claim. I see it time and time and again, every day, that when I'm preparing a case for arbitration, and usually it will be 6 years later, and I'm looking at documents, there's a particular claim that's sought to be raised, and there's just no evidence in support. Plus, the other side has responded at some point saying a particular point B, and you've never responded saying that that's incorrect. And so in those circumstances, it's very difficult to maintain a case where there's no contemporaneous evidence justifying your claim that you're trying to put forward. And so the thing I want to emphasize for all people in their construction claims is to, at the time, make sure there's a process in place for retaining that evidence, make sure there's a process in place for writing that notice or that correspondence, or keeping the relevant cost data and lost data so that you have something to rely on when you get to arbitration later on. Then we get to dispute resolution. I want to touch on, in this case, just the multi-tiered dispute resolution clauses. So in a construction contract, you'll have these multi-tiered dispute resolution clauses so that you can try to resolve the dispute informally and with less cost right from the start before you get to the more onerous and more expensive mediation and arbitration. And what I see often is that in many jurisdictions, these clauses have difficulty being enforced. Why? Well, in some cases, an agreement to agree or an agreement to have meetings has no real specificity and there's no procedural steps set out. And so it's difficult to force people to jump through that hoop. In contrast, if you had specified that for the first stage of senior representative meetings, that, for example, the senior representatives have to meet within X days of the notice being raised, and then they have to attempt 5 discussions over a period of so many weeks, and then in the absence of any agreement within so many weeks, then they can go to the next step, then that's a clear process that you can adopt. Similarly, with mediation, just saying, let's go to mediation is not an enforceable concept. You have to show how you would commence a mediation, which rules will apply, how long do you have to mediate for. And so multi-tiered dispute resolution clauses can be helpful, but if they're not clearly drafted, they can actually be a hindrance in many cases. Let me then get to the next slide on enforcement, as I've been told I need to wrap it up pretty quickly. So on enforcement, right from the outset, the first thing you want to be thinking about when you have a project is, where are my counterparty's assets? Make sure you understand where the assets are and understand whether the New York Convention applies to that jurisdiction. Because if you want to enforce your arbitration award, you will want to be able to enforce it using the New York Convention in order to just simply put it through the court and have a judgment. In jurisdictions where there's no New York Convention, then it's possible that there might be a bilateral treaty that's in place that will help you enforce your award. But those things need to be checked off at the start of your project to understand what your rights will be if you do go all the way through an arbitration and finally get an award and you want to enforce it. There's no point going through all that time and cost if you can't actually enforce it in the end. Other factors to consider is, when you get your arbitration award, that's not it. In some cases, you might be having a right to consider that there's some corrections that need to be applied. For example, I'm working on a case at the moment where the arbitration award has mixed up the names of the claimant and respondent in parts and has forgotten zeros in some parts. And you can imagine that has a huge effect on the outcome. In some cases, there may be corrections needed because there's a not that has been missed out in an award. And so these types of scrutiny of the award are very important and actually can give rise to big changes in the award in the long term. So make sure you take through that step. As the challenges to enforcement, it's always important to know for your particular jurisdiction where you're trying to seek enforcement on an award, whether the local courts are going to be favorable to enforcing it without going through the merits. Some jurisdictions in Asia in particular are quite well known for difficulty of enforcing awards and having them opened up in the merits. So it's important you check this beforehand and have that difficulty, that risk, as part of your strategy going forward for managing a dispute. So I've spoken about a number of the different risks that are involved in relation to construction projects in Asia and in the Middle East, as I've experienced them. I'm going to wrap up now and hand back to the MC, and I look forward to speaking with you in a moment on some of your queries. Thank you so much.
Thank you, Ms. Kara, for perfect ending for part 1. Toward part 2 of this webinar, panel discussion, Mr. Tung Trân will be our moderator, together with panelists. Mr. Hùng Lê, Managing Partner of CNC Counsel. Ms. Kua Lê Theng, Partner of Gong Partnership. Mr. Ki Meng Phai, partner of Belden Advocates and Solicitors, and Ms. Cara Howard, partner of Pinsent Masons. So please, Mr. Tung Trân.
So first of all, I would like to thank you so much for all the speakers for your presentation and sharing experience for the Vietnamese participant. So I just some warm-up question that I think some question that a lot of audience raised to us that when entering into infrastructure construction project, so what are the top key concern from your experience, and can you avoid briefly how to mitigate or manage such kind of risk by contract drafting? So can I invite Mr. Home to come first?
Good afternoon, everyone, and thank Tony for making the questions. I think from my experience, the concern from Vietnam perspective is I think because we are the same company and we're dealing with the same clients, we know with the same market, the same legal framework. I think the most important does most foreign contractor come in or investor come in about the legal framework. Vietnam emerging is a emerging country, and we change the law quite often at a rapid pace. That's my cost for the implementation of the project, which lasts for a long time. But not part of the issue. The other issue is about the because of the change in law, then it makes everything inconsistency. Might somehow contradictory to each other. In Vietnam, I just give example, particular in real estate and construction. We have the decree guiding on the construction contract, but very long time ago, those guidelines are only for the project developed by the government. I mean the project funding by the state budget. So everything other than that just follow their own agreement or just take a reference to the guidance for the national project. But because of the private project are different to the state budget funding project, then all of the mechanism under that guideline are not compatible to the private relationship. So I think the first and important is that about the legal framework. Each and every foreign contractor, even local contractor, they are doing big project. They need to have a great legal team, or at least the external counsel, who truly understand the risk of the change in legislation here in Vietnam, and they can, as our speaker say, they identify it, and then they allocate the risk, and they know how to mitigate the risk in terms of the legal perspective. The second I think is about the mechanisms in which the government can pay. I mean not government, the government or the state-owned company or the project management units can pay the cost for the EOT or the acceleration. Here in Vietnam, we have a very complexity legal framework on project investment, which involves not only for the Vietnam perspective, but we typically get the ODA funding. So in order for Vietnam to approve or to accept any payment, except particularly for the EOT costs, it took times and efforts from all the project stakeholder, particularly for the government perspective. I can see that very rare project here in Vietnam, the EUT cost can be implemented during the construction time. Most of the EUT costs are only deal with the dispute resolution phase. So I think that's the part of the reason why, in a statistic, we can see that the mega project developed by the government have a dispute, make a big dispute with the foreign contractor or with the investor. And I think that the last one is that about the statute of limitation. In Vietnam, we have a very short statute of limitations for only 2 or 3 years, particularly if the party agreed to arbitrage, then the statute of limitation is roughly about 2 years. If the law governing the arbitration is Vietnam law. So this is about two years, but the project lasts for 3, 5 or more. In MRT number 1 here in Ho Chi Minh City, it took nearly 11 years in order to complete. So how is that possible for the foreign contractor can maintain and retain their right to file a lawsuit against the employer if the dispute starting at the outset of the contract? So I think from my experience, those are 3 major concerns for every foreign contractor and investor. And I think for that reason, if, for example, the party want to have a better way to manage the contract or governing the arbitration clause, must be different to Vietnam law, for example. The party must not be the owner, must know how to get the approval from the upper management level in order to obtain the approval for EUT costs. This might be a temporary cost, like the metro line in Hanoi. We have a DAAB decision. At least it can somehow help the party to move on with the project rather than suspending everything or terminating the contract. So that I think what I can share with the audience, and I address this to the speaker if they have any other.
Thank you, Mr. Hùng, for your comment. Can I ask for one more speaker to share this thing? Can I invite Lighthead? Yeah, can you address this concern that the audience want to hear about? What is the top 3 concern in infrastructure project from your experience, and how we can mitigate that by contract drafting?
Sure. So the top 3 key concerns when venturing into an infrastructure project construction contract in a developing jurisdiction, my top 3 concerns, the first would be political and regulatory risk, which is what I agree with Mr. Hong Le as well. And you can address this by mitigating it through force majeure clauses. You can have stabilization clauses. And of course, it's good to be clear to specify who is responsible for this risk, especially getting government approval. That is a real concern. The second would be payment and currency risk. So this can be mitigated through maybe advance payments or performance bonds, escrow accounts. You can specify payment in a stable currency, for example, US dollars. There could be currency adjustment mechanism, or you can also consider suspending works if payment is delayed beyond a certain grace period. And the third concern in a developing jurisdiction, I would say would be things like local issues, things which concerns the local content. If there are certain local law requirements to use local materials for the building, whose responsibility is this, and consequences.
Thank you, Lighthead. So the second question would like to raise to the panelists is about MRT system. So could you please have to share more about your jurisdiction experience with in MRT system development, and if your jurisdiction has any special policy for MRT project development? Can I
Yes.
come first with Kara?
Sorry.
Yeah.
Hi. So for the MRT in Hong Kong, we've had significant issues over a number of years in relation to unforeseen ground conditions. And originally, we had a contract which provided that there was a geotechnical baseline report, and any conditions that were differing from the geotechnical baseline report entitled the contractor to an extension of time and costs. This was a major issue because there were significant geotechnical problems with the ground, with, for example, garbage that had been buried in landfill not being recorded on any public register, for piping being in places as unexpected, or simply because where the TBMs were going through the tunnel, the type of rock was different to that it anticipated, and it caused breaking of all the knives and the cutters on the face of the TBM, which meant they all had to be replaced at a greater frequency and causing more delay. And so as a result, there has been significant payouts for a number of parties over the last few years. And so the MTRC is now using a new contract form. And the new contract form that they've adopted is the NEC form, which has slightly more restrictive grounds for claiming for unforeseen ground conditions, and is overall a much more restrictive contract compared to the original Hong Kong form. And in that way, the MTRC is seeking to limit its loss going forward for similar types of risks.
Thank you, Kara. Man Fai, do you want to add in something?
Sure. I think similar to what Kara has mentioned, I think, and in fact, that's what I've covered earlier in my slides as well. I think the most challenging part of it will necessarily be geotechnical risk, as well as especially when you do something in dense populated areas. So I've talked about that already. I think the second bit that will be necessary is the contractors coming in with the necessary technology for them to mitigate the risk insofar as having to detect geotechnical issues, and also having updated machinery that allows you to do your works and ensure that there's no breakdown that will necessarily cause further delays to the project. So I think in Malaysia, what we have done, and as an evolution from an MRT project as well, is that we have now resorted to awarding different packages necessary to different contractors, identifying which contractors has the best specific qualities to deal with that package of works. So if a particular package has underground works, then we make sure that those contractors come with those necessary experience and the necessary equipment for them to ensure that they can do works that leads to that. Another part of MRT that usually is challenging is having to deal with public sentiment, because you're going to be doing works in a public related area. You're going to need to have an entity that is able to deal with the PR, the public relations part of it, insofar as managing complaints, doing the necessary surveys to ensure that there is no damage that is caused to surrounding buildings, surrounding properties and all that. And I think that's something that I've covered along earlier, where we said we had necessary SPVs. So companies and who has experience already dealing with this, so that you don't get the project being seen with multiple injunctions being stopped on because of public complaining that it has noise pollution or it has cracks that they suffer due to surrounding properties. So I think managing it, for getting the right people to do it is the key of it, and ensuring that your contract sets out who is the party who is responsible to coordinate this risk, setting out the necessary standards, and don't just use vague words like, to ensure that it is publicly safe, to ensure that you abide by local authority standards. I think in today's world, to ensure projects can move specifically, you will need to be more specific in identifying what type of risk and what are the types of standards that you require the contractor to abide by in order for him to ensure that your project in MRT goes smoothly without unnecessary hindrance.
Thank you so much, Manfai. Regarding the MRT system, we have one question from Q&A addressed specific to Lathan that can you share more about in Singapore, the MRT system developed by the government or developed by the PPP mechanism? Can you share more about this? Yeah.
Yes, sure. So, in the beginning, in the 80s, the MRT system was fully owned and operated by the state, by the government. Then in 1998, there was like a hybrid PPP, where LTA, made a 30-year deal with SMRT, which is actually a private company, but wholly owned by Temasek, to run some lines. And then in year 2000, SMRT became a listed company. But in 2016, following criticism that SMRT had prioritized profits over providing good public transport system, SMRT was delisted and LTA bought back SMRT's rail assets, returning them to government control. And due to operational issues, MRT services reliability and frequent breakdowns, today the government has introduced a new framework called the New Rail Financing Framework to improve sustainability and efficiency of Singapore's rail network. So under this framework, LTA manages the rail infrastructure and assets, while the operator focuses on day-to-day operations. So in respect of the operating assets, LTA owns them and makes decisions on replacing and upgrading them, while the operator is responsible for their maintenance. So the operator collects the fare revenue paid by commuters and pays the government a license charge for using the operating assets. There is a profit and risk-sharing mechanism. So if the ridership is lower than projected and the operator suffers financial loss, LTA will share some of the shortfall in the revenue and profits. Conversely, if the ridership outperforms expectations, then the operator pays an increased license charge. So there is such policies. Well, this is a fairly new framework which is applicable to all lines except for one particular line, the Thomson East Coast line.
Thank you so much, Lathan. For the next question I received from the audience, I think this question a lot of people care about recently due to the change in the world or something. So the question is, what are the effective way to manage the foreign exchange or inflation risk in cross-border infrastructure contract? Can I come first with Kara?
There are a number of grounds that you can potentially raise. The first one would be the most obvious, which is the price escalation clause that I referred to in my session a little bit earlier. And so if you have the price escalation clause, this means that you can seek to rely on it in your contract if you can establish that the particular materials for which you've agreed a price index have been increased. However, in many cases, this is not incorporated. And so parties might need to work out other means of claiming for an increase in price. For example, where there is a delay and you've been pushed, for example, as a result of an employer's compensable event into a period where the price has then jumped. In that case, then you can rely on your entitlement to claim for consequences of delay and claim your loss and expense of that additional uplift as part of as a recovery of that inflationary cost.
Sure. Mr. Hong, do you want to add in something about how the party can mitigate the risk of inflation or foreign exchange?
Oh, no, I don't have. Yeah.
Okay, so we can move to the next question. It's a similar topic is that a global geopolitically unstable right now? So could the speaker can help to avoid how the party can mitigate the risk in relation to disruption in global supply chain, and then affect the implementation of long-term infrastructure project. For example, if we want to buy something very abroad and have something worse in there, so the global chain is disrupted, the contractor cannot deliver the good on the site on time, so we call the delay and something like that. Can I come first with Manfai?
Okay, sure. I think insofar as that is concerned from the contract drafting perspective, I think it's quite important for us to identify what then becomes force majeure. I think the definition of force majeure is often overlooked by parties when they're drafting the contract. They would use what is standard language or use general terms, like war, hostility, and supply, and so on and so forth. I think especially in today's world with so much volatility, there will be need for parties and lawyers to look into definitions of force majeure, expand them, and perhaps to some level even put in more level of specificity to cover and to engage for this kind of risk in order to mitigate those. That's one part of it. The other part of it, perhaps I can think of, is this. A lot of times, the construction program, for example, may or may not be part of the contract documents that is incorporated and creates a legal obligation. If supply chain and procurement issues, and tying back to, I think, what you mentioned earlier about foreign currency exchange and all that, if procurement is going to be something that needs to be mitigated or needs to be balanced, then I think it is also wise for parties to work out whether or not you want procurement programs to be part of that contract, and also to work out with your employers to ensure that there could be early procurements, and also perhaps ensuring that certain payments are upfront made so that you can lock in your supply of materials as part of an overall contractual regime, so that way you ensure that your supply chain doesn't get disrupted due to change. A third option and a third suggestion that I may give is that when you are, I think when contractors go into a particular contract, especially if you're on the top, you're very much focused on your upstream contract drafting. So a lot of parties comes in and they only look towards ensuring their contract with the government or with the employers are very properly drafted and looked after, but they forget to look downstream as well, which is your contracts with your suppliers and so on and so forth, to also mitigate that risk. So don't forget to look upwards and downwards to ensure that, from both perspectives, be it your recoverability from your employer, but also ensuring your downstream contracts with your suppliers or subcontractors are properly lined up and drafted, so that you can then try to mitigate both risk from both ends. I hope that helps.
Thank you so much, Manfai. I think that more and more questions come from the audience, so I try to speak up. I think this question for Mr. Home and Lathan, that to what extent that the liquidated damage can be enforced in infrastructure project in Vietnam and Singapore? Can I invite Mr. Home to come first?
Yeah, I think liquidated damage here in Vietnam is still remains a controversial topic. We SCL Vietnam, as a Society of Construction Law, we have a number of topics, and under a number of conference we do with this, but we haven't reached on a kind of an agreement on how we will deal with it. But I think generally speaking, if it's under the law of Vietnam, we will face the chance if the party agree on an amount of the liquidated damage without any supplementing or clarified on the element or the nature of liquidated damages. Because here in Vietnam, we are a C4 law system. We have a principle that damage must be real and direct, rather than an agreement or the generous agreement. That's why we still have unclear under the civil court that the party might agree on another way to compensate the damage. But because of that, the unclear provisions, the practice still have different perspective on the LD, the liquidated damages. But in general, I think arbitrations are more likely to accept the LD, but the cost perspective, they might interfere with what exactly the nature of the LD. Rather, is it a penalty or is it damages? Because if they think that is a damages, they will require the evidence of how much the party have suffered for that and what are the evidence for that. So I think here in Vietnam is quite challenging if we adopt the LD without clarifications, without supporting particular under the contract. So be careful for that. Yeah.
Lathan, can you share more about Singapore perspective on LD clause?
Yes.
Yes.
Yes, the position on LD in Singapore is quite clear. It's settled. I think, as mentioned earlier by Kara, it follows the English Dunlop pneumatic position. It is enforceable so long as it represents a genuine pre-estimate of the likely loss and it's not a penalty. So it will not be enforceable if it's a penalty. We usually ask the question, is this to punish? If it's to punish, it's not enforceable. Is it to compensate for the delay? Then it will be an enforceable LD. That the position is quite clear in Singapore.
Thank you, Lathan. I see one question addressed directly to Kara. The question I have for FIDIC 2017, I see there be a permanent mechanism, but for saving time, may I skip the mechanism and go straight for the arbitration? Kara, can you help with this?
Yeah, that's a great question. Thank you so much. I think it depends if you're, first of all, are you in the position of the employer making the decision under the contract as to whether include the DAB mechanism? I'm going to assume that you are. And so in this case, my experience in Asian projects is that the benefit of a DAB will depend on who you appoint. If the DAB membership is independent, unbiased, and they appreciate the complexities of construction law and the type of claims that are being arisen, then it can be a helpful mechanism. But in more cases than otherwise, I see that the DAB is appointed in a jurisdiction where there's a significant control on who those DAB members might be, so that for a foreign contractor, there's a high risk of an unfavorable decision. And then you have the issue of having to then decide whether you're going to issue a notice of dissatisfaction and go to arbitration anyway. So I think it depends. If I'm an employer, I would probably include it because I have I'll be able to postpone any obligation to pay even longer. But as a contractor, if you can avoid it, I think that it would be better to go straight to arbitration, or otherwise, depending on the dispute, perhaps have instead an expert determination procedure being put into the contract, so you can get somebody who's technically skilled and able to understand the dispute without the complexity and the cost of a full-blown arbitration. So it's a bit of a convoluted answer, but the answer is potentially maybe.
Thank you so much, Kara. And one more question for Kara, I think regarding to the requirement for notice of claim in FIDIC contract. The case come from the audience is the contractor and there is dispute between the contractor and the employer due to the sole asset. And the contractor, in good faith, they want to cooperate with the employer, so the contractor did not serve a notice of claim in time, and then the party bring the dispute to arbitration, whether the notice of claim requirement is strict obligation against the contractor to move forward with the case.
Okay, that's another really good question. So essentially, it's a question of whether the contractor should be pressured by the employer not to issue notices and hope that they'll be looked after when they raise the claim in the end. So my first response is you must comply with the contract, particularly if you're in a common law jurisdiction and you have a condition precedent notice provision. You must comply with the contract. And what I tell my clients who are suffering from the pressure from the employer not to put those notices in, because they want to maintain a relationship, because they want to do the right thing and show that they're acting in good faith, as you say, is to put a cover letter on the notice and say, I apologize profusely. I'm very sorry. I'm bound to do this. It's part of my obligation under the contract to do this. Apology, 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 but put the notice in anyway. And in that way, you protect your right, because once you have protected your right, then it's open to go forward and pursue that claim if you wish. Once you have lost that right, then it's very difficult to do so. And the employer often turns around and says, oh, there's no notice, or there's change in personnel. And so the person who agreed with you at the start of the project that it's okay not to issue is no longer there anymore. And so you have nothing in writing to say that they said you didn't need to put the notice in. The other alternative is in some cases you can establish notice was issued simply because you've referred to the particular element in a meeting minute or maybe in a letter of some other sort that's not labeled as a formal notice. And in some jurisdictions that can get you by. So for example, there's cases in Australia where that has been said to be enough. Otherwise, you might want to write to the employer and say expressly, you've said to me I don't need to issue notice and that you'll look after me. Thank you very much. I will rely on that going forward. And so you have it in writing. And when it comes to the point where they refuse your claim, you can refer back to your letter and say, well, you said this, and so you waived your right to claim, and therefore, where do we go? But again, that all leads to dispute and more time and cost. So the best thing is just get your notice in on time.
Thank you so much, Kara. So I think the short conclusion from Kara is don't be so nice and skip your notice of claim, right? I can hear one more perspective from civil law jurisdiction like Vietnam, biết không? Do civil law have any honest perspective on this?
No, I don't think I have. No.
Yes. So thank you. I have a few more questions here. So I think I have a very interesting question here about how can the development of technology can help mitigate the risk in infrastructure project. Can I come first with Manfred?
Sure. I think the advancement of technology has definitely helped to at least crystallize or to help reduce to some extent the amount of disputes that will come. I mean, with technologies that you see, be it from BIM, will then help you track progress. So issues that we face in the past in disputes, for example, what is the actual progress on site and what was actually completed, all of that can be mitigated. You now have Primavera, you have Econex, things like that will again reduce the amount of dispute between parties. For example, we used to have disputes about whether notices were sent, if they were delivered, who received it, was it actually received and all that. Today with Econex, all of those issues can be mitigated or can be reduced quite substantially because it's in a total system that's out there. In fact, I think even to the least formal type of communications, I think we have seen an increase in trend in people using WhatsApp and all other different kinds of communication basis as part of a project management tool, which I think all of it helps document what has transpired in real time, issues that are there. But ultimately, I think it comes back to this. Yes, technology has advanced, but I think contractors will also need to take into account what is the cultural sensitivity of it, because at the end of the day, it's users, whether we actually use the tool. And I think that leads to what Kara mentioned earlier, right? As to whether or not you raise the necessary notices, or because you're culturally being sensitive, you decide not to raise them as a matter of dispute avoidance. That could harm you in the long run. So perhaps I think as much as technology is there, it is still important for human beings to use it in the appropriate means to satisfy what is needed in your contract as sufficient notice.
Thanks so much, Manfai. Lê Thanh, do you want to add in something?
Not really. I agree with what Ming Fai said. I just wanted to share that I read something, not that I've had any experience with this, but there are some AI and machine learning algorithms that can analyze project data, forecast errors, and suggest mitigation steps. So this sounds really useful, but this would be a totally different topic altogether on AI and how we should still keep an eye on AI while using it as a tool.
Sure. So I think we may have another topic, another webinar about how
Yeah.
AI can apply in construction, right? Thank you so much. The next question is, I think, for Mr. Home, about the law applicable for infrastructure construction contract. For the foreign element contract, can the party apply another law other than Vietnamese law for the infrastructure construction contract?
Yes, yeah. In Vietnam, if we have a foreign element like a contractor, we are allowed to select another law system. But I think the law governing the contract must be distinguished with the law governing the arbitration clause. I think referring to a foreign law system might not be a great choice from my experience. The thing is that firstly, we are executing a construction project here. If we are dealing with a foreign law system, it would be the question whether all the law system, including the safety requirements, etc., so on and so forth in environment would be compatible. That's number one. Number two is whether the party truly understand that law system. If a foreign contractor come from a common law system, they will refer to use the UK law. But then Vietnam law is a civil law, then it would be an adverse effect to the state-owned company, for example. So the question of whether they understand the law is a gray area as they need to consider. I think what they are more about is about the law governing the arbitration clause. Because under the Dutch law, it might not be necessary to be the Vietnam arbitration, commercial arbitration law. This might be the law of the seat of the arbitration or another law. The Dutch law will govern how the party will proceed with the dispute resolution rather than the substance of the dispute. But I think if we refer back to Vietnam as a governing law, then assets LD is one of the area that we need to pay attention to that. And because some of the other regulation here in Vietnam might not be relevant to what, for example, common contract like FIDIC feature. Here in Vietnam, we have a different approach for the payment at the state at the commission. We don't recognize clearly whether post the defect notification periods, then the party can submit the final statement. Here in Vietnam, we submit the final statement nearly at the time of the project completion. So the question of whether the defect liability arises and then the contractor cannot fulfill its obligations, then what is the legal basis for that? Is it under the law or under the contract? So I think what I can share from Vietnam perspective is Vietnam governing law in Vietnam for the contract still be okay, but then we need to make it sure whether the contract the party are using, like FIDIC, how can I say, compliant or compatible to Vietnam law, so that we need to retain a lawyer who can review and give you the comment on that. And but of course, particularly for Lê Thanh say, This is about the arbitration clause under the common jest. We need to pay attention to that because I have experience with a very big project here. Local contractor, they adopt the Vietnam law as a governing law of the contract, but then they say the dispute should be Stockholm in over there overseas. So they say it's no way for them to engage a lawyer over there to represent them under that arbitration. So they have to select another way to settle the dispute. Yeah, so that's what I can say.
Thank you so much, Mathung. So can I hear very briefly from all the jurisdictions like Hong Kong, Singapore, and Malaysia? And in your jurisdiction, can the party in cross-border infrastructure contract can choose the foreign law as the governing law? Can I come first with Kara?
Hi. Yes, in Hong Kong, you can choose whichever governing law you would like to choose for your contract. You have to just beware in some circumstances of a party claiming that Hong Kong law nevertheless should apply because of the nexus to Hong Kong if the project is actually in Hong Kong. But in most cases, it will be held, the agreement of the parties will be upheld.
Thank you, Kara. Lathan, how about Singapore?
Yes, that would be the same for Singapore. It's up to parties to choose the governing law, and if they expressly agree on a law which has got nothing to do with the jurisdiction where the project is, that would be enforceable.
Thank you. How about Malaysia, Manfred?
Likewise, I think freedom of contract does allow parties to choose the law that governs the contract. But perhaps I will have just two cautionary things to say about that. Number one, I think in choosing the law of the contract is very important. I think Hung has mentioned it earlier, to understand what are the substantive rights of it. So how you deal with LADs, how you deal with concurrent delays. If you choose a particular set of laws that are different from your own jurisdiction, you need to understand substantively how that helps you. Number two, I think the consideration that you need to have in mind is how does that law of the contract play into your dispute resolution mechanisms that are available to you. So in Malaysia, in Singapore, in Hong Kong, you all have statutory adjudication. But and that's accessible to contractors to seek for payment issues. But if the law of the contract is a different jurisdiction, does that complicate matters? Does it make it more difficult for your recovery? Are things that you need to consider because your dispute can happen in between the project? If you need a quick answer and you need a quick resolution, but your contract complicates matters by referring to a set of laws that are different, will that delay your recovery and delay the restitution that you seek for? And then you need to consider it from an overall perspective, whether that fits into what you need as a dispute resolution regime for the contract as a whole. So those are the two considerations I would add on for parties to think about.
Thank you so much, Manfred. I think that we have 10 more minutes before I had to let everyone go home. So I try to facilitate. And the first one is a lot of participants want to hear about the PPP. So the question is, given that the Vietnam is considering shifting its role from public investor to allowing the private investor to take the lead. So could you share the key experience with the PPP from your jurisdiction? Can I come first with Lathan?
Yes, Singapore's experience with PPP has been mostly successful, except for a few cases, which I would like to elaborate on. Most of Singapore's PPPs are a variation of the design, build, finance, and operate, where the private sector is in charge of designing, building, financing, and operating. So they would naturally be more concerned with feasibility and profitability, while the government is more concerned with political and regulatory risk. The first PPP model was introduced in the early 2000s for projects such as water and sewerage treatment, incineration, IT infrastructure, defense facilities, transport, and education. In fact, at one time, the government was very pro PPP and even issued a procurement guideline requiring all government infrastructure projects above 50 million Sing dollars to be considered for suitability as PPP projects. So generally in the sector of utilities and water, it has been quite successful. In fact, there was also in education where the Institute of Technical Education, ITE College in the West won some Asia Pacific PPP Deal of the Year by Project Finance International Singapore. But not all PPP projects have been successful, and even ITE, which won an award, reverted to the traditional procurement model when it developed the next campus, which is its ITE College Central. So in Singapore, the most high-profile unsuccessful PPP would be the Singapore Sports Hub. It was a 1.33 billion 25-year PPP between the government and a private consortium of 4 companies. And even though it's for 25 years to design, build, finance, and operate the sports hub, not even halfway through the 25-year concession, in 2022, the government terminated the PPP and took over the management of the sports hub. The reasons are because the interests were not aligned. The consortium was very profit-driven, which worked well in the building phase, but was not sufficiently aligned with the government's interest in the operation phase, because the government's focus was having community programs and some social objectives. And also during operation, there were many complaints about low quality and faulty amenities, and also issues with operation. There were international football matches which drew flag for the poor condition of its pitch, all quite embarrassing. There was the infamous 2014 Jay Chou concert, which was marked by leaky roof and very bad sound system, and general public unhappiness because the consortium was charging $26 million rental fees to the government for National Day parade rehearsals. So the locals, the Singaporeans, expected the consortium to actually discount their commercial interests for the collective good of the nation. So this experience, this not so good experience with the Sports Hub had influenced the government's decision not to adopt the PPP for the Changi Airport Terminal 5 development. This is a huge development. Terminal 5 costs about 8 billion, and when completed in the mid-2040s, it will increase Changi's total passenger to 140 million a year and bring Changi to the status of a mega airport. So actually with Changi Terminal 3, there was of course a delay of 2 years during COVID, but what they did was to make use of that delay of 2 years to redesign with modularity and flexibility so that the new terminal can operate as smaller, separate sub-terminals when needed. So this is to cater for potential contingencies such as COVID-19 if it does happen again. And they also redesign it to adapt to climate change. The broader Changi East development, where Changi Airport is sited, is designed to be 5.5 meters above sea level. This is to mitigate the effects of extreme weather and climate change, especially rising sea levels and heavy rainfall. Yeah, so PPP is not really suitable for Terminal 5 because Singapore wanted a single airport operator across 5 terminals to ensure consistency in service, in standards, and in the system. Because Changi is like an icon to Singapore, so it's important for the government to be in charge of operations and to have a greater say and control of the project. So in summary, Singapore's experience with PPP is mixed. Successful for utilities sectors because the contracts, the structure are standardized, the output is easily monitored, and the underlying technology is stable, but not so successful for infrastructure projects with a strong social and symbolic element like the Sports Hub, where there could be changes to technology, changes to the users' pattern, and also stakeholder priorities. So it's a mix.
Thank you so much, Lathan. I think that I just have 4 minutes, so I would like to wrap up with the very last but not least question about dispute resolution. This question will be addressed to all the speaker and would like to hear your sort of voice about this. The question is about resolving the dispute in infrastructure project can be a lengthy and cost-consuming process due to its complexity. So what are your recommendations for the party when they involve in the dispute resolution? Can I come first with Kara?
This is a very good question too. I think that it depends what your relationship is with the other party. So in large infrastructure projects, there's often a joint venture relationship. And so if it's a joint venture dispute, your priority might not be going to full-blown arbitration. It might be to retain the relationship and work together. And so what we've done for clients is to assess their claims and counterclaims in the same way we would do for arbitration. So you have a legal aspect, a delay, quantum, and you get it all together for them. And you give them an idea of, well, what's the likelihood of success? What are the weaknesses? What are the strengths? But then arm the person who's going into negotiation with all this material to understand the range of a good outcome. And then they will use that to maintain the relationship and continue with the new project, because they may be tendering together somewhere else, or they may already have other projects online, and so they can't damage the relationship. So in that type of circumstance, the relationship is what was key. In other cases, it could be a circumstance where there's no relationship, even if it was in any case, and so you don't mind going to dispute. In that case, you need to assess and understand what the costs are involved. What are the time consequences of an arbitration? Because they have propounded arbitration as this quick, easy resolution, but it's not. It's at least 1.5 years, 2 years, sometimes 3 or more that you're involved in an arbitration, and that will be the time of your staff who are witnesses being involved, and it's the time of preparation proceedings and costs, and the uncertainty factor of not knowing what's going to happen at the end. And so it's important to really assess with your lawyers at the start, well, what is the value of my claim? What are the strengths and weaknesses? Will I succeed? What are the likely costs? What is the likely time frame? Would I prefer to put this money into investing in the new project, and then determine a strategy based on what your needs are, and then go into arbitration knowing full well what your case is, which claims are worth dropping because you don't want to pay your costs for those claims, and be forewarned before you go into arbitration.
Thank you so much, Kara. Manfai? Yeah.
Sure. I think my advice would be therefore for parties to, at the onset, actually have a better understanding of what are the dispute resolution mechanisms that are available in the particular jurisdiction, as well as what is then needed to be incorporated into your contract for them to match. So in jurisdictions where if ultimately all you will have are the courts, then perhaps you will need to have your multi-layer, multi-tiered dispute resolutions in your contract to deal with them. If you have, for example, in jurisdictions where you have mandatory and legislative regimes, then how do you cut down and mitigate and minimize the number of multi-layers? That's one. Two is also, if parties from the onset can perhaps have an idea of what kinds of disputes that will happen and what sort of dispute resolution mechanism that will fit, that will also help. So you may want from the very onset say, if you have disputes up to a certain value or a particular dispute that's only technical in nature, whether your contract has specific mechanisms to deal with it. If it's technical, you have your expert determination. If it's value, up to a certain value, maybe perhaps you want decisions to be final and binding and acceptable by parties, because that way, ultimately, when you do have a dispute in the end in arbitration, perhaps many of the little and smaller disputes could have already been resolved, and you can de-escalate the issues, and that way come to and avoid a lengthy and cost-consuming process. that perhaps is my 2 cents on the issue.
Thank you so much, Lan Thanh. And Lai Thanh, do you have any short comment for the party?
Yes, if it's a long-term contract and to avoid a long-drawn arbitration, then do consider DAB or DAAB. That's quite helpful. But if you are going for a full-blown dispute, then those things that Kara mentioned earlier are very important. You have to maintain robust records and project documents. You have to use your project management tools, Procore and Econex. You need to train your project team on claims and dispute protocols so that they don't miss on the timelines. Also to engage legal and technical experts early. And lastly, consider expert determination on discrete technical issues or disputes that could help break up the dispute to solve things.
Yeah, thank you. And the last thing, you get the right lawyer, right? Mr. Hong, can you have to wrap up? Yeah. What is your short advice for the party?
I think nothing more I can say. I just endorse what the speaker said. The arbitration should be the last and what the party forced to do, rather than to do it at every time. It's very cost and time consuming, very painful. Can I say 2 or 3 years, maybe for 4 years too. And the enforcement of the forced arbitration awards in Vietnam is another challenging. So please don't think that arbitration is the last the good way. Rather doing with the DB. That's the real solution for the party. And in order to achieve a great outcome, the project record, the contemporary records must be maintained very good way so that they can submit to the party for their understanding. That is the real damage. What are the positions? What they can mitigate so that the party can better reach agreement rather than going further than that. Yeah. So that's what I can say. Yeah.
Yeah, thank you so much for all speaker. To be honest, I would like to say that I would like to hear more and more from you, but I think that is the time up, and it's now 5:30 in Malaysia, Hong Kong, or Singapore. So I promise that I had to let you go home today, Friday afternoon, and you stay here until now. And would like to say thank you so much for all the speaker and all the participants who stay with us until now. Thank you so much, and hope you already gain some insight and experience from our speaker, and hope to have you again in our another webinar of CNC Council. Thank you so much.
Thank you.
Thank you so much, Kara, Mei Feng, and Lang Thanh. See you all. Yeah.
Thank you all.
Thank you so much.
Thank you. Bye-bye, everybody. Thank
Bye-bye.
you.
Bye.